Motion was filed 5/8/25. I guess it's 45 days from today. Let me do that calculation real quick. 6, 23, 25. It's looks like August 7th, 2025, Your Honor.
Okay. Let's go on the record on DC 239443, the Grand Treviso Condominium Association versus the Restoration Nation, Inc. Counsel, make your appearances.
Rob Skeels for Lurch Bates, third party defendant.
Joshua Rager for the Grand Treviso Condominium Association Incorporated, the plaintiff.
And Kathleen Gogol for Restoration Nation, Inc.
You may proceed.
Thank you, Your Honor. This is Lurch Bates' motion to dismiss pursuant to 91A. As you're aware, the 91A motion is a motion on the pleadings. It is our contention that the Grand Treviso has pled itself out of most of the causes of action. We're not here seeking dismissal of the entire case. We're here seeking dismissal of the causes of action other than breach of contract. Grand Treviso is alleged, which must be taken as true, that Lurch Bates is an architectural and engineering firm. Lurch Bates performed professional services consisting of a repair plan to this condominium and agreed by contract to perform a certain number of construction observations of the work in progress, which is defined as engineering in the Texas Occupations Code. There are actually 9 separate contracts between Grand Treviso and Lurch Bates in this matter. There is an original prime agreement. There are 8 supplemental service authorizations. Each one of those authorizations is signed by both parties, describes a set number of construction observations to be performed, and that is all in contract. This is a breach of contract case. This is only a breach of contract case. This case has been ongoing for, I believe, over 2 years. My client, Lurch Bates, was more recently added to the case earlier this year. Since that time, Grand Treviso has amended their petition 2 additional times. So their allegations are their allegations. The Grand Treviso's response is essentially this: there are potential factual circumstances that exist which would allow my claims to proceed. That is not what we're here about today. We are only looking at Grand Treviso's allegations. Their response has not pointed to one of their allegations at all. This motion is important because, as I've told you, there are 9 separate agreements between our 2 clients, which detail the services to be performed. And each one of those is signed by both parties, and each one of them contains a limitation of liability provision. And to be very straightforward and upfront with you, I'm trying to clean this case up with this 91A motion because a summary judgment will follow on the limitation of liability, which is not nothing. It's $109,000. Our liability is limited to that amount. But it is illogical to spend more than that amount defending a case on attorney's fees and hiring experts. And I would like to get this case dwindled down to what it really is, file a summary judgment on the limitation of liability and proceed on that basis. The purpose of Rule 91A is to streamline the case and judicial economy for all the parties. Again, this is not an MSJ, it is a 91A. The Grand Treviso's response is essentially, hey, listen, we need to do more discovery. There could be facts which would allow our claims to proceed. And so we want you to reserve judgment based on those facts. But
their first argument seems to be that as to the plaintiff's negligence cause of action, that the motion is procedurally defective because it was filed more than 60 days after the defendant was served with that petition. What is your
This is defendant's amended 91A motion. The negligence claim is not part of that motion. So the causes of action at issue are negligent misrepresentation, implied warranty for professional services, and DTPA. I think I've covered them all right there. But the negligence allegation, our answer deadline was extended a couple times while we were arguing about these very points, and the amended motion is not addressing the negligence cause of action, so we're just going forward on the remainder of them.
Okay.
As far as the strategy going forward, as I explained to you before, the limitation of liability applies regardless to negligence expressly. So that doesn't really bother me too much that that's not part of this motion, but I would like to get rid of those causes of action that Gran Treviso has pled itself out of. As you know, Rule 91A requires dismissal if the allegations, as the Gran Treviso's allegations taken as true, do not entitle the claimant to relief. There is no evidence contrary to plaintiff's response. Gran Treviso my client has not cited any evidence whatsoever. The only evidence we've cited is the plaintiff's allegations as contained in their third amended third-party petition. And now, in order to defeat the 91A motion, Gran Treviso, all they had to do was point to allegations which would allow their claims to proceed. But instead, what they've done is they said it's possible that some circumstance might exist that would allow our claims to proceed, but they haven't cited a single allegation in their entire response. It's because their response, the allegations taken as true do not allow them to proceed. It is a motion on the pleadings, and the allegations of Gran Treviso require dismissal.
I'm sorry, I didn't mean to interrupt you. Go ahead.
Oh, no problem. I'll take a breath in 1 second, Your Honor. What plaintiff is asking you to do is say, hey, don't do this now. Let's do some additional discovery. Let's see if there are facts that would allow our claims to proceed. But that's not going to help. 91A is a motion on the pleadings. You can only file it within 60 days. No evidence.
Let me ask this. What is effective about their pleadings when it comes to the negligent misrepresentation?
The economic loss rule bars those claims. Am I able to share my screen, Your Honor?
Sure. Just give me a
Thank
second.
Let's see. I've lost it now. 1 second. So I've set out the law in the motion, and I know you're familiar with the economic loss rule, so I won't belabor the point. But a negligence claim or negligent misrepresentation claim is not available if it is just an allegation of deficient performance of a contract and the damages are the same. In this case, and I've put it together here, the allegation, regardless of the cause of action alleged, is identical. The allegation is not for any design services my client performed, it's the construction observation. As you can see in both breach of contract on the left side of the screen and negligent misrepresentation, the allegation is that my client failed to identify deficient work that was not constructed in accordance with the plans and specifications. That is our contractual obligation. The negligent misrepresentation claim and the rest all identify the exact same, material breach of the contract, whether it's called a duty or a breach of contract. It's that they were built in a good and workmanlike manner in accordance with all plan specification, design professionals' recommendations, etc. It is all the same allegation, just under different heading. So because the duty breached is contractual, the economic loss rule bars recovery in tort. If the harm is limited to the subject matter of the contract, which the plaintiff has expressly pled, if you'll see in the facts section, it says Lurch Base is an architectural and engineering consulting company that contracted with the association to design the architectural repair plan and to perform construction administrative services, quality site observations to identify defective construction at the project. Frankly, I don't think there's any clearer example of the economic loss rule barring tort claims, because the duty allegedly breached is just the contract. So there's no duty independent of the contract. And secondly, it seeks damages for contractual expectancy damage. There's no separate injury involved. And I think the case law is very clear that the economic loss rule bars the negligent misrepresentation claim. That was the subject matter of the LAN STV versus EB construction case. That was a negligent misrepresentation claim as well. That was dismissed on summary judgment because it was just a contractual duty between the parties, and there was no independent loss other than the subject matter of the contract. I'm going to try to keep my arguments as concise as possible, Your Honor, and try to leave myself a minute to respond.
What exactly is the issue with the DTPA claim?
There are a couple issues with that. Number one, as a matter of law, the breach of a contractual promise cannot constitute a DTPA claim, period. And as you can see in both the breach of contract and the, I think it's on the next page, actually. This is the DTPA. The breach of contract claim and the DTPA claim are identical. It's a representation that Restoration Nation completed the construction in accordance with all applicable plans, specification, and design professional recommendations. It's the identical allegation in the breach of contract claim. I cited lots of case law, which I'm sure the court can read for itself. It's a very black letter Texas law. Breach of a promise to perform a contractual obligation cannot, as a matter of law, constitute a DPA claim. Number two, it is barred by the professional services exemption. Architectural and engineering services are professional services as a matter of law. I don't think there's any argument by the plaintiff at all disputing that. I don't understand what the response is exactly, but architectural and engineering is universally accepted to be professional engineering services, so it is exempted by statute. I think plaintiff cited one case, which was Lloyd's versus Godfrey in its brief. That was a summary judgment proceeding in which the court determined as a matter of law that a lawyer's solicitation letter to a potential client was not professional services. Here, and this is why I have the allegations here, the plaintiff has pled that we are an architectural and engineering consulting company. And for all purposes, that's the only thing that we can consider. The plaintiff has alleged it. The occupations code defines professional services and the practice of engineering to include, quote, engineering for review of the construction or installation of engineered works to monitor compliance with drawings or specifications. And that's Texas Occupations Code 1001.003C9. I think the case law establishes that engineering services are professional services and they are expressly exempted from the DTPA. So for those two reasons, the DTPA claim cannot proceed. And I guess the other cause of action that we're challenging is the breach of an implied warranty. For the very same reasons, Texas does not recognize the breach of an implied warranty for professional engineering services. The plaintiff's response, and forgive me for summarizing, is that, well, under certain circumstances, it is possible that public policy would impose an implied warranty for professional services. Now, plaintiff, just like the other causes of action, has not cited a single allegation in its third amended petition that would raise that specter. But more importantly, I've cited, I believe, 7 or 8 cases, 3 of which are specific to architects and engineers. There's Irwin versus Nortex Foundation Designs, holding there's no implied warranty for a professional engineer. Glenn v. Nortex Foundation, no implied warranty for a professional engineer. And then Lan STV versus EB Construction, which is a 2014 Texas Supreme Court case that held that there was no implied warranty for a professional architect. Point being that while plaintiff argues that public policy may allow for such an implied warranty in certain circumstances, all Texas courts have already considered whether public policy would impose an implied warranty for architects and engineers, and uniformly they have found they do not. There's no case law cited in plaintiff's briefs, and for that reason, the implied warranty cause of action should be dismissed. And so I'm going to conclude with I hope, an opportunity to respond to any of the plaintiff's points. I understand that there is an inclination to allow a case to proceed and discover additional facts, but that would defeat the purpose of 91A. A 91A motion could never consider any later discovered facts. It's a motion that must be filed within 60 days based exclusively on the pleadings.
All right, I'm familiar with the history of 91A. I was around when it got.
Well,
So,
the purpose is to,
No,
the legislature said adopt rules to promote the prompt, efficient, and cost-effective resolution of civil actions. That's what I'm trying to do here, Your Honor.
Okay.
And if you were to accept the argument offered by Gran Treviso, just because it's possible that facts may exist that would allow their claims to proceed, Rule 91A is meaningless. Its purpose has been frustrated. It could never be granted. And with that, I'll submit to the court. And
All right. I'm going to take a quick 2-minute or less than 2-minute break. I'm just going to give me 1 second. Okay, all right. Response.
Yes, Your Honor, thank you. I first want to start off with Rule 91A requires the defendant, in this case, Lurch Bates, to establish that our claims have no basis in law or no basis in fact. They don't make an argument that we don't have a basis in fact, and so they must prove that we have no basis in law on the claims that we establish here. In order to do that specifically for the negligent misrepresentation claim, they've argued that the economic loss rule is an absolute bar to any claims for negligent misrepresentation in this case, but that's just not what case law shows. Economic loss rule is a very fact-intensive exercise. The court must look at all the facts surrounding the case, must look at all the facts of the contract, review all of those, and then make a determination of whether the economic loss rule applies or not.
Are any of the cases cited by either side address whether or not you can use a 91A motion to dismiss a claim based on the economic loss rule? Have there been any courts that have done that?
And that was a point I was going to bring up shortly, Your Honor. The Lurch Bates failed to cite a single case as to any of these claims of action where a court actually dismissed a claim under 91A. Every single case they cited is either on a motion for summary judgment or after a final verdict has been issued.
Is that correct?
The cases cited, yes. I don't know offhand, Your Honor, of any 91A specific cases, but I mean, I
It seems
think,
like the economic loss rule is kind of it is kind of a fact specific analysis, isn't it?
but it can be, Your Honor. But here, our world of facts are limited here. Our facts are limited to what the plaintiff has pled. And if there are exceptions to the economic loss rule that the plaintiff has pled, then they need to point us to those facts. They have not cited a single allegation. And as you know, we're limited. We don't get to go outside of the plaintiff's allegations. We don't get to look to the contract. We have to take the plaintiff's allegations as true, and they have pled it.
Are there any cases that say that you are required to plead an exception to the economic loss rule? The economic loss rule is a defense, right?
Yeah, it is a defense, Your Honor. But
Why would they have to plead an exception to the economic loss rule if that's not part of their cause of action?
They have pled that there is a contract covering the tort causes of action. They have not pled anything that would suggest an exception to the economic loss rule. And if we're only looking at the plaintiff's allegations and taking those allegations as true, that is where we live. That is where we are. We don't get to make up hypothetical facts that could exist. We must take the allegations as true, and the allegations pled as true say that there's a contract covering the negligent misrepresentation, and that I'm seeking the identical damages. Those are the two elements of the economic loss rule. They could point to an allegation
that they're seeking the same damages for both.
Absolutely. There's no differentiation whatsoever. They're seeking damages for
I've read a lot of petitions though that don't. I've never seen a petition where there's, I mean, usually there's kind of a, at the end they'll have damages pled, but they're not pled by cause of action. Is there some rule out there now that requires damages by cause of action?
No, Your Honor, but they have specifically pled them by cause of action, and each one is practically, for all practical purposes, identical. If you'll look at the end of each cause of action they've pled, they illuminate the damages that they are seeking, and they're all the same. And that's why the economic loss rule is also called the independent injury rule. And I like that better because it makes a little more sense in my head for the economic loss rule. Is basically saying if you can recover these contracts under, or if you can recover the damages under contract, you can't recover them under anything else because there's no independent injury.
Okay. Anything else, Mr. Rager?
Yes, Your Honor, just to address that directly. you'll see in our response to the motion that the defendant does have an independent duty as an engineer in the state of Texas under the Texas Administrative Code to meet certain standards in his practice of engineering, irrespective of any contract that may or may not exist. So there is an independent duty in the Texas law defeating the economic loss rule. Furthermore, in terms of identical damages, this is a contract to repair certain balconies at a condominium community. The contract only encompasses the balcony repair. The nature of these damages is that water was allowed to intrude into the structure of the building itself beyond just the balcony structures. And so there are damages to portions of the condominium that are outside the scope of the balconies alone. That water migrated further into the project than the contract covers. And so there are damages outside the structure of the contract as well, thus defeating the independent injury as well.
Okay, let's talk about the DTPA.
Yes, so 2 points on the DTPA, Your Honor. First, we are not alleging just mere contract breaches. That is part of our claim. But in this particular case, Lurch Bates made representations above and beyond the contract itself, and it's for those representations that we seek damages under the DTPA. Specifically, they were obligated to identify defective conditions at the property. What happened in actuality is they actually took photographs of defective conditions. They issued a report stating that these were actually compliant construction. So they went beyond just identifying defective construction. They actually said this construction is okay. This particular way they did the balconies just fine. They made that representation that the work was in good condition when in fact it was not. It's these material misrepresentations that the association relied on that we're seeking recovery for. Once again, that's based on their independent duty as an engineer to be honest in their dealings under the Texas.
What about the professional services exemption?
It's not an absolute exemption. In order for the court to determine whether that exemption applies or not, the court would have to consider facts which are just not in evidence at this time. That's why 91A here is inappropriate. It would be more appropriate for a motion for summary judgment after the evidence in the case has been developed. Specifically, the DTPA says that this exemption does not apply to, and then it has 5 separate categories where this exemption does not apply. One is
can you share screen those five exceptions?
I have them in my motion. I don't have the code pulled up, but I can pull them up in my motion if you'd like, Your Honor.
Sure. Can you blow that up a little bit?
And if you look specifically at exception number 2, it's a failure to disclose information under a certain section. And that's part of what we're alleging. We've also alleged unconscionable conduct, breaches of warranty, things like that. And so whether these apply or not requires a factual inquiry, because this information is not contained within the pleadings. Pleadings aren't required to be that fact intensive. And so in order for those facts to be developed, that would have to take place in a motion for summary judgment. In this case, Lurch Bates has just jumped the gun. They're asking us to plead facts that are so specific. There's nothing that requires facts to be pleaded with this specificity. And so we need to develop the evidence, develop a record, and then if it is as they say it is, they can file their motion for summary judgment, they can cite their evidence, and then the court can rule and do a factual inquiry where appropriate. It's not appropriate under 91A.
Response to that?
Your Honor, this is the argument that's made in every one of these. Would you mind dropping your share screen? Thank you. This is the argument that's made in every 191A hearing you've ever had. We need additional discovery. If you can avoid a 91A motion just by saying, hey, we don't have enough facts, you should do this in a motion for summary judgment, this motion could never be granted. It would completely.
I will say that this very, very rarely are 91A motions. I'm not sure. Anyway, 91A motions in my court, at least, I say maybe one of these a month. So they are pretty rare because I think they're most attorneys can figure out a way to plead around 91A, but.
Yeah, and I understand, Your Honor, and that's kind of my point. this is since February, we've had 3 amended petitions switching and changing the causes of action in response to our threats of 91A and our correspondence.
But isn't that also part of the rule? The purpose of 91A is to make sure that the pleading is proper and that they've obviously have maybe had some improper pleadings before, but maybe they're proper now. I mean, there's nothing inherently wrong with repleading, right?
Oh, no, not at all. My point there is only that they've made 3 valiant efforts since February, but these causes of action are clearly barred. These are contract claims. And what is happening here, Your Honor, is that they want to sue us under the contract, but they don't like the limitation of liability provision. So they're switching and changing causes of action to try to plead around that limitation of liability. But the facts that they have pled do not allow you to sue an engineer for an implied warranty because Texas law doesn't allow it. The facts that they have pled does not allow you to artfully plead that the breach of this contract is really a breach of the DTPA. When Texas law is very clear that the breach of a promise to perform a contractual obligation is not a DTPA claim and cannot be brought as a DTPA claim. I think this case is the reason 91A exists. These claims are clearly barred by Texas law based upon the allegations which we must accept as true. We don't get to go in and say, well, there could be some other facts that I have not pled that would allow these claims to proceed. I mean, the very first page of their response says, established, it says, recovery for these claims may be allowed under certain factual circumstances, but then it doesn't go on to point out any allegation in their pleading that would raise those certain unspecified factual circumstances. So I think when we apply some very clear law, Your Honor, humbly, to the allegations that they pled, this case should just go on with what it is. And that's a breach of 9 separate contracts detailing the services that my client was to perform and limiting their liability.
Right. Mr. Ray, is there anything else?
No, Your Honor, all of our responses are in the motion. 91A requires a factual what defense is asking the court to do is undertake a factual inquiry and ask us to plead every fact in existence in our petition, and that's just not what the law requires.
We are Texas. We're fair notice pleading. We don't have Iqbal or anything like that. So anyway, all right. Well, I'll take a look at this. When did you say the deadline was again?
I had it at August 7th, Your Honor.
Okay.
And I say that, and now I'm questioning myself on whether that runs from the date of the hearing or the date of the filing. And so if you'll give me 1 second, I want to make sure I'm not telling you something wrong, Your Honor.
Let me look. You know, they've just passed it was signed by the governor yesterday that's putting in a deadline for judges to rule on summary judgments too.
Oh, really?
Yeah. It goes.
Okay,
It does.
so I did tell you something wrong. It says granted or denied within 45 days after the motion is filed. This is an amended motion. And it was filed. I'll double check that too. Five eight, I believe. Oh, that's
So
a short.
looking at like January 20 or June. Oh, is today the deadline?
It kind of. Hold on one. I just want to double check, Your Honor. I was 519, sorry. But the rule also says, so I got July 3rd. But it also says that an amended response restarts the deadline. Let me see.
I
An
see that.
amended motion filed in accordance with B restarts the periods in this rule. So I think, I mean,
And what day was that filed?
the amended motion. Yeah, the amended motion was May 19.
So that means we have until approximately July 3rd, right?
That's what I've got, yes, Your Honor.
Mr. Rager, does that sound about right?
It does, Your Honor.
All righty. I'm sorry, Miss Gogol, did you want to say anything? You kind of didn't talk much. Just want to make sure you didn't want to say anything.
No, Your Honor, I don't have a dog in this fight. I'm just here as part of the case to know what's happening with the case, but I don't have anything to say on the motion.
Okay. Right. Well, guys, appreciate it. We'll try to get a ruling out by July 3rd.
Thank you,
And
Your
Your Honor,
Honor.
just to follow up, you'd mentioned binders. Would you like physical binders delivered to your court?
Yeah, I need one binder, both sides. You guys can work on it together. All the briefing on all the live, and I don't need the previous versions of the motion with the live motion, live response, and the live petition that this is based on. So just the live pleadings with any case law highlighted for both sides.
Yes, Your Honor.
Okay.
Can you get that to me by tomorrow afternoon?
We'll
Certainly.
confirm it and get it done, Your Honor.
Okay. Thank you, guys.
Thank you.
Thank you.